Ok guys, nous live là et nous pral tande ensemble qui Jean Bagala te yé nan fait circuit à pile côte. Nous pral revivre ensemble ça que t'as dit. Bon, me rappeler tout le monde, jeudi a, c'est pour nous contextualiser j'en ai là. Nan fait circuit à pile côte, qui ça qu'a discuté pour qu'à comprendre le dossier a. En fait, il y a plusieurs de ces capacités. Mais d'abord, premier dossier a, c'est est-ce que de manière légale lorsque administration complante décidé camper en masse statut ou ensemble de monde qui te gen kat travail déjà révoquer statut. Nous connaissons que le dossier ça a été bloqué en premièrement par Talwani dans Fédéral Code. OK? Italien a appel code, livré dans Suprême Court te dit gouvernement ou capable camper, pas vrai? Et en attendant que le dossier a poursuivi dans l'appel code. Et c'est ça qu'a fait là. Chaque temps, yo te gen à peu près 20 minutes et le juge yo t'a posé aux questions. OK? Et l'autre élément yo te tout, en fait, de toute façon, l'autre aspect qui a bien pour yo parler tout, monsieur, moi, juge Talwa, ni pas bien pour parler de bail. Ça c'est lenteur qui gagne sous monde qui fait, par exemple, résidence, asile, TPS, m'a parlé de monde Biden qui prend temps, ça sont l'autre dossier. Talwa ni pas parler de ça, parce que nèg yo presque pas procès. Yo passé au lot de procès, mais yo fait le très lent. Bon, ok, guys. Nous allons regarder ensemble, ça n'a pas essayé faire, n'a prend grand idée ça qu'a dit. Nous allons vivre ensemble avec vous. Donc, on va pas comprendre que qui Jean bagay la yi. Nous allons aller dans appeal court et nous allons attendre des questions et nous essayer bon yon vivre ensemble ça qu'a dit. OK? OK, on allez guys. So c'est commencement de quand yo pas oublier que nous gen avocat gouvernement en bas et puis gen moun qui défend les migrants yo en bas. Donc c'est ouverture là a demandé pour venir présenter. Et partagez la blague guys, OK? Là, c'est juge qui a parlé, qui a orienté qui vient pour le faire débat. Parce que tous les deux, quand ils pour le gagner pour le défendre, OK? Donc, on va avancer. De toute façon, je dis c'est pas deux process qui a challenge vraiment. Là, c'est parti gouvernement pour le parler, OK? So, en d'autres termes, yo mandé appel côte là, yo supposé rejeter case là, en suivre ça suprême côté dit, en reverse rejeter ça qu'a discuté. C'est gouvernement qui a parlé là, OK? Parce que là, après, il pose une bonne question, ou dit Suprême Court là, de parler de mérite, parce que Suprême Court n'a pas parlé de mérite, voilà le mot. Parce que Suprême Court là, l'LD dit, il faut camper, elle parle de ces mérites là. Non, c'est ça. C'est une belle question, juge l'a posée là. Oh, sorry, gen moun qui dit me son pas sorti. Bon, moi, attends, moi, guys. Bon, moi, fait ça, ok, sorry, hein. Bon, fixer ça. Sorry, ok. Bon, moi, fixer ça, ok. Moi, ça, mon yo dit là. Pardon, hein. Bon, mon minute simplement. Next stop. Sorry. Et bon, faut regarder. Bon, mon minute simplement, ok? Un minute, guys. Bon, mon minute.
prevail on appeal here.
We should give that perhaps not automatic.
Donne-moi un moment, guys, okay? Sorry, guys. Donne-moi un moment. Give me a second. Give me a second. Bon moment, okay? Pour me parler de... Bon, une minute, hein? Ok, c'est ça, bon, là, sorry. Desktop. Hold on. Give me a second. Property. Hold on. Desktop. Voix me sorti, mais c'est voix qui parle dans voix qui parle dans microphone pour me faire bail, OK, attends-moi. Speaker. Voix qui parle dans bail là pour qui me sorti. C'est un moment. C'est un moment, guys. Il est bon là, guys. En fait, Jean là, l'a dit, en fait, c'est le gouvernement qui a parlé là, il dit que parole à son bagage qui est purement discrétionnaire. Il argument pas, il va pas avancer là. Vous comprenez? Il avait dit, OK. En fait, yo-même, yo dit là, ça va bien, il a dit comme quoi, pour eux-mêmes, les hauts campés parole, ça pas sujet de révision de la part du pouvoir judiciaire. C'est ça, le gouvernement a argumenté là.
Director of the CIA as to what his actual, beliefs were. There's no meaningful law to apply there, and that's why the APA's committed agency discretion bar applied in Webster, and why it applies here, as well as in the Supreme Court decision in Buarfa, which also supports it. I'll note too that the district court's analysis, at page 26 of the appendix, simply ducked the key issue here, which is she used ellipses to ellipses out the opinion of the secretary language, which is the crucial factor here that makes makes it just like what the CIA director deems and what the Secretary of DHS deems in Webster and Buarfa, respectively. And so,
Can I focus in on your argument that is at the beginning of your brief, that the INA deprives the district court of jurisdiction?
absolutely, Your Honor.
I didn't see a lot of,
En fait, pas oublier là, j'ai argument là, tout argument, c'est juste là qu'a posé question. Parce que l'argument gouvernement là, c'est comme quoi l'a dit, la loi agent le fait là, c'est comme quoi lui retirer droit pouvoir judiciaire là, pour t'a adressé autorité, nous même gagné pour le camper par discrétion. C'est comme quoi il pas sujet à ça, une judicial review. Et ouais que juge a questionné argument là, c'est ça qu'a fait là.
case law cited there, and I'm wondering what your best case is for that.
Your Honor, I will acknowledge that there's not much case law either way on this. I think our best case law is the Samira case out of the Seventh Circuit and the Hassan case out of the Ninth Circuit, which recognizes clearly the discretionary nature of parole decisions. I think going by the text of the statute itself makes very clear that it's discretionary. I think, too, a key part of the INA's text there is that it doesn't say that the individual decision must be discretionary in order to trigger the bar. It says it turns on the nature of the authority, and the nature of the authority of parole is widely recognized to be discretionary. I believe this court did so, too, recognized as much in case I'm up.
Let me make sure I understand the breadth of your jurisdictional argument. Suppose the statute said that the secretary in her discretion can withdraw parole only after interviewing the parolee and determining X. And the secretary then said, in my discretion, I'm going to revoke parole, but without any interview. Would that be something that a court could say, you've exceeded the scope of your authority as opposed to misapplied your authority, therefore we have jurisdiction to review it?
Your Honor, I think that likely.
En fait, on va remarquer tout argument avocat là, c'est un mot qu'a répété souvent ici là, c'est discrétion, discrétion, discrétion. Et c'est sous base ça. Et on va remarquer question juste ça vraiment belle, il dit que lorsque par exemple nous il décide un scénario côté qu'il révoquer un bagage sans pas même questionner moun, sans pas gagner aucun fondement. Est-ce que là pas ta supposé gon review, c'est vrai qu'on a une discrétion mais c'est pas aucune base. Est-ce que discrétion veut dire c'est l'école laguée et c'est ça juge là poser la question là.
It would not be reviewable. I'll certainly acknowledge that would be a harder case than this one.
You said that would not be reviewable?
OK, donc ils sont as well. Je dis bien bon côté abséné monsieur, vous comprenez l'offre yo qui t'ont parlé, on dit OK. Mais l'on décide bah là, monsieur on commence on petit enchaîner là.
I believe so, Your Honor. I think that when Congress has an explicit bar judicial review, that necessarily means that some cases that might otherwise be meritorious will not be reviewable.
But isn't there a distinction? It's not just that the case is meritorious. When Congress passes a statute, it grants the secretary certain authority.
Yes.
And it then says when the secretary exercises that authority, we can't second guess it. But it's a wholly different thing if the secretary exercises authority beyond that given by the statute. Then don't courts routinely review such exercises?
Voilà. Donc de toute façon c'est vrai que on a discussion mais secrétaire, nous parlons de nous, il pas qu'à aller au-delà de ça qui est écrit et c'est ça juge a questionner là.
I don't believe so, Your Honor. And I do think the case would be very different as to the committed to agency discretion language bar, because in your hypothetical, now you do have law to apply. You have an interview standard that would be something that a court can supervise rather than just the mere opinion of the secretary. It's also conceivable you could think that the reading the bar, in light of that sort of specific statutory provision, would reach a different result. But I think the plain text of the statute as written is that if it's a discretionary decision, and ultimately these are still discretionary decisions, that judicial review would be barred. In particular, I think that if a bar on discretionary action turns on, if its applicability turns on how that discretion was exercised, that's no bar at all. If you have to reach the merits in order to determine whether the jurisdictional bar applies, then that bar isn't really a bar, it's just a nullity that does no work.
So then when Congress here said that you could establish a parole policy, admit someone on it only on a case-by-case basis, your logic would seem to say that even if the secretary did not do it on a case-by-case basis,
Yeah.
that would be unreviewable.
Your Honor, I think that is an accurate statement.
Ok, voilà, il dit que le Congrès a dit que faut qu'aucun campé et parler à case by case basis. Il dit, j'en ai parlé là, c'est comme quoi vous voulez dire que même lorsque secrétaire là, et même le ministre là, fait li sans case by case, Jean se fait là, et bien même là encore, on dit que li unreviewable. Unreviewable veut dire que ou pas doit réviser. C'est ça n'est pas parler là. N'est dit, c'est discrétion ministre là, pas que personne moun qui gen droit pour faire une révision, pour faire une remise en question. Et c'est l'argument ça, avocat a montré là. Là, on dit c'est discrétion et on bien dit que li pas review, ça veut dire nous pas qu'à réviser pour nous dire mais qu'on mal fait. La justice comme quoi pas gen droit pour pointer droit yo pour dire ça pas bon. OK? Et on va remarquer à chaque fois juge gen des questions embarrassantes. Il a posé avocat gouvernement.
Until about a couple of months ago, because perhaps recognizing that very scenario, Congress enacted the Lake and Riley Act, which specifically makes reviewable the grants of parole where they violate the statute, and it provides for standing with states. I believe they have to have financial harm that exceeds $100.
Well, you would say it was unreviewable before that statute was passed.
Yes.
That would be your logic.
Yes, Your Honor, and in fact, that comports with basic principles of statutory interpretation that Congress doesn't enact nullities, that amendment was meant to do work. And it does work by, by providing for a review that would not otherwise exist.
Do you read the statute as requiring, well, let me ask this, what do you regard as the purpose of the parole in this situation?
Yeah.
Your Honor, it could be many purposes. It's because the granting of parole is in the discretion of the Secretary. I think that any purposes that the Secretary deemed relevant in order to make that determination are things that she could consider when terminating it. I think that's underscored too by making terminations turn on the opinion of the Secretary. There's no restrictions on what the Secretary might have opinions as to what good public policy is. And so, I don't think there's law to apply there, and I also don't think there's any restrictions necessarily on what could be considered in there.
So if we put to one side the jurisdictional issues and go to the merits, didn't the Secretary here, at a minimum, have to determine that some purpose of the parole had been served?
Your Honor, I don't believe that's reviewable, but setting aside the reviewability decision, I believe that as long as she concluded in her opinion that that was the case, then the statutory requirements have been met here.
And so what purpose was determined to have been served in this instance?
There were many purposes that were determined to be served. For example, she pointed that the prior one was the prior categorical grants of parole or categorical programs were designed to try to ease stress at the border and to try to regularize or provide some order to a very chaotic situation. Secretary Noem determined that prediction was not, in fact, correct, that it was not having the public policy benefits that the prior administration anticipated they would, and she provided that of a plethora of reasons why she was terminating these programs.
Let me ask,
Là, elle parle de but, pour qui raison que vous te mettez parole. Vous comprenez? Pas oublier que dans phase argument, côté que avocat gouvernement parlé, avocat moun ba dernier pas parler non, et juge a questionné argument qui a pas avancé. C'est ça qu'a fait là.
when the secretary gave her reasons, would you understand they're distinguishable from the reasons the then secretary gave in the Regents of University of California case, which were not enough?
Yes, Your Honor. I mean, certainly the key holding of the Regents case was that the Secretary failed to give sufficient weight to the reliance interests of the DACA recipients in that Regents case. The Secretary here did consider reliance interests, and I don't believe the district court found any fault whatsoever with how the Secretary Noem analyzed those reliance interests.
Let me ask a practical question. What is happening now?
Your Honor, it is, after the Supreme Court stay, it has been restored to where the Secretary and authority is often delegated to line officers can make case-by-case determinations whether or not to grant parole or to not terminate.
Fait yo mande ça qu'a passé qui Jean moun Biden yo reconnu là avocat tente expliquer, OK?
terminate them. The effect of the stay is, the stay of the 705 stay is to restore the prior status quo of the rule, where that can be done on a case-by-case basis, but absent some case-by-case circumstance that those paroles determinations have been
Let me
terminated.
just following up on that. Do you have any information, or in general terms, or statistically, as to since the Supreme Court's ruling, if any individuals have, in fact, on a case-by-case basis, continued to have parole out of these four groups of individuals from these four countries?
Your Honor, not specifically. I know that there are separate programs that are not currently on appeal here that.
Faites question posée là. Est-ce que au moins, gen au moins un grain de moun Biden côté que gon décision qui fait pour lui case by case basis. Et c'est ça y a demandé là. Ils sont bagay fait en masse et c'est ça y a pas attaqué là. Et on que juge sorti sous bail ça. Est-ce que au moins ils te font considération cas par cas parce que c'est ça qui est écrit dans la loi.
That the district court entered a stay of as well. As a result of that stay, I know that.
Does this pertain to the new appeal that was filed?
Yes, Your Honor. And so I know there have been thousands and thousands of such applications considered, leading to, many individual grants. So I know certainly for that one, there are being considered. I know there are, the case-by-case example, continues to exist after the Supreme Court stay. I don't have specific statistics.
Would it be possible, let's say, maybe by Friday, a Rule 28J letter to tell us if, in fact, any individuals have gotten parole after the Supreme Court order?
Sure, Your Honor. I can.
Okay, so if you could do that by Friday, we'd appreciate that.
But otherwise, your answer is from the humanitarian parole for the four countries here, the people who had that parole, that has now been terminated for them.
It has, as a general matter, there may have been instances where the case-by-case exception was invoked, or that hasn't breached a determination yet.
Okay, that's what for the Rule 28J letter, if you could let us know.
Does the new notice of appeal affect anything we do here?
I don't believe so, Your Honor.
Okay, and sort of a different question. In the past, when parole has ended, have the humanitarian parolees been subject to expedited removal?
Your Honor, my understanding is that they have previously. I don't know with the programs, but it has been expedited removal has been applied previously to those.
En fait, je pose la question, est-ce que dans le passé, depuis vous finissez retirer et parler moun, est-ce que automatiquement vous avez expedite removal? Pas oublier que une raison que vous voulez camper parler c'est pour vous capable faire expedite removal et c'est question ça juge la adresser là.
Whose parole has been terminated, and I believe that's consistent with the regulations.
How have in terms of the programs themselves, how have those ended?
Your Honor, I can't think of a specific example off the top of my head. I know that there certainly are many instances where parole is granted and then ultimately terminated, and that may be based on individualized circumstances. It may be on broader ones. I think that's important, particularly why terminations are often done on a broad basis. If, for example, you were to grant parole because there's a civil war going on in a country, and the Civil War ends, you would naturally, think that you might want to address that as a sort of categorical.
Yeah, so I guess that's my question to you. In the past, if you know, how has that been addressed? Or has it been that the parole has just been permitted to elapse?
Yeah, I'm not sure specifically. I mean, it would depend on how long those programs lasted.
En fait, on remarque comparaison juge l'a fait là, il a essayé d'expliquer dans le passé, puisque parole c'est bon bagay qui pas existé, c'est toujours là. Qui gens été kon terminé. En d'autres termes, question intelligente, juge l'a fait là, yon bagay qui l'a déjà, mais j'ai été qu'on a habitué dresser et puis mais qui j'en n'aurait vinn adresser là. C'est en d'autres termes, la question là c'est gens juge a essayé de montrer qui gens que ça n'aurait fait à différent par rapport avec ça qu'on a habitué faire. C'est ça l'a essayé de montrer là.
Would have to be 2 years unless there was some sort of interruption in the continuous presence requirements. I know that's not on the record here. I don't know off the top of my head how that's operated.
Let's turn to your argument about has been paroled, which I think I understand you to mean your interpretation of that language from the expedited removal statute is that parole is an ongoing status.
That's correct, Your Honor. I think there's an important antecedent point, which is that is only one of a plethora of rationales given by the Secretary, and so we think those others provide a fully sufficient basis to support that. But in terms.
Are you conceding that point then?
No, I'm not, Your Honor. I'm just pointing out that even if they were correct about it, it still can't form the basis of an affirmance. But we do contest that. And I see my time has expired. If you don't mind if I continue.
Please continue answering that, and I think we may have some other questions, so.
I appreciate that, Your Honor.
The plaintiffs will also get.
Ok, yo bay chaque 20 minutes. Donc, 20 minutes, monsieur, après, ce qui est fin passé là. Ok, il a posé les 3 petites questions toujours.
The additional time if you get, so it'll be equal for both, so.
Of course. I don't believe so for several reasons. The first is we pointed out the text of the expedited removal statute uses the past perfect tense, and the past perfect tense is used to indicate something that may have previously been the case but is no longer the case. And so the use of the past tense rather than, the pluperfect tense rather than the mere past tense. If it said had been, or was granted parole, we think that plaintiffs would have a much stronger.
Je souligne un petit bail là. En fait, nous, gens là, compliqué. Ça va adresser là, c'est si l'eau plus que parfait, si l'eau pas c'est composé. Ça veut dire, dans cause loi, même sous temps écrit bail là, le font différence. C'est ça la va adresser là, vous comprenez?
Argument, but had been paroled is different, particularly under the Turner cases we've cited. I think there's two other important textual parts of the parole statute itself, which indicates that expedited removal is appropriate for those whose parole has been terminated. The first is that the statute says, following a termination, the person, quote, shall forthwith return or be returned to the custody from which he was paroled, end quote. And so that's a clear indication that you should return to the status, before the grant of parole. And that's underscored by the second and an even more important language that, quote, thereafter his case shall continue to be dealt with in the same manner as any other applicant for admission to the United States, end quote. Applicants for admission are who expedited removal are applied to. I mean, that is a clear indication as to what Congress had in mind. Those that are not applicants for admission cannot be subject to expedited removal. Those are the category to which they apply. To be clear, it's not all applicants for admission that can be expedited removal, but applicants for admission are the entire universe of people to whom expedited removal can be applied.
Let me ask a different question in a different area. When you look at the statute itself, had this been a criminal statute, perhaps the rule of lenity would be applied. But I have not found any Supreme Court cases, and I think at least our circuit cases don't apply the rule of lenity to immigration cases. So what's the government's position as to that if we were to read the statute?
Your Honor, we certainly don't think the rule of lenity applies. That is a purely criminal context. Immigration is civil. I'm not aware of any application of the rule of lenity to immigration cases. So I don't think it applies there, and I'm not aware of any sort of parallel construction that might apply in the immigration context. To the extent that canons apply in the immigration context, they often recognize the very substantial deference owed to the executive in enforcing and construing immigration laws.
Then let me follow up on that. In interpreting or reading the statute, if we go to the Russello case, I believe it's pronounced that way, and there is some case law from our circuit suggesting that when you have a statute, it doesn't have these separate sections. It could be the same section, different parts of the statute. And for example, here at the beginning it says case by case, and then it's omitted, and the further on it doesn't go case by case. Would you agree or disagree that our case law and the Russello case would warrant that the individual case-by-case requirement not apply to the termination of parole?
Your Honor, let me.
On l'autre fois encore, avoir que juge retourner sur question case by case là. En fait, avant de dire avocat, vraiment presque fin de parler parce qu'il y a 20 minutes. Mais on a remarqué plusieurs fois, juge a questionné sous notion de le fait que l'on a terminé pour paroler son bagage qui fait. Ouais, il vient avec ça souvent, ok? Donc, son façon pour dire que le juge est conscient que ça aurait les termination en masse, on sait le quoi, son acte, son action qui fait contre la loi. C'est ça la PC de montrer là.
Address the canon and then I think maybe address more broadly. I'm not sure exactly which bucket you would put it in. I think it's either the Rossello presumption or the expressio unius canon, where you specify that grants must be made case by case and then have silence as determinations. I think that's probably the expressio unius canon. You could also see it as the Rossello presumption because you put it in one place but you didn't put it in another. I think those, operate kind of in tandem and serve complementary purposes. They both kind of explore the same basic intent that Congress has explored here, which I think is also conveyed by the text itself. I think there's a couple other key indications, too, that underscore that that's the correct interpretation of the statute here. I think history, context, case law, and the nature of the action are helpful. So if I can, let me just unpack those. I think the history is important here, particularly the 1996 IIRA amendments. Plaintiffs' argument, which the district court accepted, was that the use of the singular in this statute compels individual determinations. But if that were correct, the singular has existed previously, and in 1996, Congress made a point of inserting that case-by-case language for grants of parole. Under plaintiffs' interpretation, that it was a complete nullity, that it was completely superfluous, it did nothing that didn't already exist, that Congress hadn't already required by the use of the singular. I think context is important too. We've cited other examples in Title VIII that make clear that when Congress wants individualized determinations, it is expressly, mandated as much, including, for grants. I think this court has case law, as well as the Supreme Court, that make clear that a clear statement is required to divest agencies of their discretion to act in broad categorical manners. I think the Supreme Court's case in Lopez does so, as well as this court's case in Muniz. And I think the nature of this authority as well really lends itself to categorical resolution. As an example I brought up earlier, if parole is being granted because a civil war is then ongoing, when the civil war ends, you might expect that the agency would quite reasonably act in a categorical manner to say that the parole is no longer served. I think another categorical...
Let me ask you, in the case, for example, of civil war, if the civil war ends, there's a government, it's great relations with the United States, and would there be any reason to then return each individually, but after a hearing, case by case, or that's the sort of example that it's probably your best example for doing it en masse, right?
We certainly think it's a very good example. I think there's another example presented by this case here as well, that these programs were created on a categorical basis that the parole programs would alleviate pressures at the border and help improve our overall immigration system. And that was a very categorical rationale of Secretary Mayorkas, and one in which that Secretary Noem just profoundly disagrees with. And so because she believes that that prior categorical rationale no longer applies, it makes sense to unwind those.
Remarquez, argument par eux dit que, étant donné que l'est que tu as désigné par Oléa, c'est un bail qui était fait de manière catégorique, bon, c'est argument par eux, mais on va remarquer, leur après rempli programme bail dans un côté, où tu m'as expliquer raison particulière pour chaque monde. On va qui va qu'un gon section, où tu mettre comme ça, qui pour montrer que l'essentiel de notion par Oléa, son bagage qui est toujours case by case.
Parole grants that were done on a very categorical basis.
Let me ask you one more practical question. As I understand it, the district court's preliminary injunction is going to be stayed no matter what we do with this appeal for some substantial period of time until the cert petition time is gone or the cert petition's been adjudicated. Is there going to be anything left at that point?
Your Honor, this hasn't been briefed. It's something that I started to give some thought to during moot arguments. And I think the answer is that much of the practical significance of the case will be drained, but there will be enough collateral consequences that persist to avoid formal mootness. I think there will be, for example, aliens that might be put in expedited removal on the basis of this termination, who might be subject in the future to a reinstated order of removal. They could, therefore, whether or not these terminations were valid will ultimately, determine whether or not that reinstated order of removal could be done. I think there may be others who could.
It could be somebody found here who should have been removed or left, and the person's found here illegally, and it's charged with 8 U.S. Code Section 1325 or 26. And then, this might be necessary to show that the presence is not lawful, correct?
I believe so, Your Honor, and I think there may be adjustment of status in things where the requisite time period is triggered in the delta between when parole would have expired and when it was terminated. So I don't think there's likely to be formal mootness. Certainly no party has suggested as much.
En fait, ça, juge la posé là, la parle le fait que si on pas agi vite, est-ce que gon ban bagay qui pas mute? Ça veut dire que si on était, pas bien que son bagay qui toujours la justice. Donc, si on dit la continuer la justice, si on gata pour un bon valet moun, on gata déporter yo, ou bien gen des séries de moun, pour raison pour l'autre calde fait application résidence, yo dit bon, te gata illégal, est-ce que qu'on est là, si yo même yo pas couru décider, est-ce que bataille là pas tout perdu? C'est ça, juge la posé là comme question. OK?
But I think, as a practical matter, the numbers involved are going to be much smaller, I think, as a result of the Supreme Court stay. But I don't believe that it's likely that there will be formal mootness as a result of that stay.
Let me, another area. Let's assume we were to find that parole termination has to be individual. Would the fact that the letters by email were sent to every person, because every person who's paroled has to have an email account, everybody received those letters unless they don't check their email or change emails, would that be sufficient individualized termination? And the letters say, I believe it's 30 days. Would that, in the government's position, be individual terminations?
Your Honor, I believe so, and I believe that's the thrust of plaintiff's position. They've taken the position that individual determinations are not reviewable, and hence, if it were that sort of individualized notice, I believe, it's part of the strangeness, I think, of their jurisdictional argument that if you do something 500,000 times, it's not reviewable, but if you do it once, it suddenly becomes reviewable. But I think that's the necessary implication of plaintiff's argument, that they say that the individual ones are not reviewable. So if the Secretary does such notices and could take the position that the notices provided through existing accounts satisfies it, I think that could be the individualized determination. And I don't see how that would be reviewable.
Let me ask, if it were reviewable, or let's assume, because again, here nobody's asking for a due process hearing. What else could the government do to do individual terminations, aside, because again, there's not a due process claim, it's simply, just notifying the person of their termination.
So there is no due process argument at issue, and I think that there is
this case before us.
Well, and I think there is suggests that there would be no such, because you have to be admitted into the United States in order to get rights beyond what Congress has provided you by statute.
So for anybody who's listening, when you're paroled, you're in theory in the United States, but you're not admitted to the United States. You're granted that parole status.
That's correct, Your Honor. It's the entry fiction that is at the heart of immigration, that unless you're admitted to the United States, immigration law treats you as if you're at the border.
Okay. Let me also ask, parole, well, when it's granted, it's for urgent humanitarian reasons or significant public benefit. I read the brief filed by the amicus states, and their position is that obviously this is humanitarian, and also there's significant public benefit, employment, within the communities. But also, my question to you is, do we look at that humanitarian in determining under the APA, if we could review, do we look at what the states characterize those humanitarian purposes, or we look at how Secretary Noam understands and characterizes those purposes, which, both sides have different views of those humanitarian reasons or significant public benefit. Who prevails between those?
Your Honor, Congress has given us the answer.
Mais là, il parle de public bénéfice, le fait que un ensemble de states qui te fait brief qui montre que catastrophe, bagay ça vient sous pile monde qui t'a travaillé dans plusieurs secteurs. Et là, on parle de public bénéfice, chaque monde ouais l'en façon, gouvernement même public bénéfice, li ouais que monde ça yo, vous comprenez c'est dangereux, vinn bay problème. Pendant que state yo dit c'est des monde qui viennent contribuer, au contraire, camper yo plus aller contre bénéfice de l'intérêt public. C'est ça, et juge l'a pas adressé là.
there. And so assuming that neither of the jurisdictional bar applies, the Congress has explicitly made the opinion of the Secretary the controlling one. We recognize the states may have policy-based disagreements with the administration. They may have profound disagreements with it. But in this case, Congress has not just invested authority in the Secretary, it's made her own opinion to be the controlling standard for what decisions will be made. And in that posture, it's a question for the political branches and here the Secretary as to how she wants to proceed.
And tomorrow, or I don't mean tomorrow, but let's assume at the end of this term, or if she were to resign, another secretary come in, the new secretary could say, well, we're coming back with the parole, and that's, the statute does allow that if or the circumstances change. Let's assume there's a civil war in Nicaragua tomorrow. She could say, well, yeah, we're going to take him, all these individuals, they can be paroled again. That can happen also.
Absolutely, Your Honor. That this is something that's committed to the political branches, with the slight caveat that one of the political branches here, Congress, has enacted the Lake and Riley Act so that the grants of parole would potentially be judicially reviewable now in a way that they weren't, a year ago.
Can I just quickly turn to something I was a little confused about in your briefing? So this is on your argument that the parole statute doesn't permit categorical termination. You speak about the previous administration's parole grants as being categorical. Does your argument depend on that?
It doesn't, Your Honor. Certainly, the Secretary potentially could have taken the position that because the prior programs were unlawful, that's a basis to unwind them. But that was not a rationale that was supplied in the rule, and it's not a rationale that we are presenting to this court. We do, other than to note the strange contortions that are required for this. There's a strangeness to where the grants, these categorical grants, are somehow immune from judicial review, but when you try to unwind them, they become reviewable.
If we found that the grants here were made on a case-by-case basis under a categorical criteria, you'd still argue that the statute itself permits termination.
Absolutely, Your Honor. And it is not a rationale of the terminations that the prior ones were unlawful. Instead, there are a variety of rationales offered, including that the immigration-based.
Une fois après, le juge a posé question sur le fait que c'est de manière catégorique, en groupe, que vous décidez de camper. Toute question tourner autour de ça. Il m'a rappelé dans cette section-là, c'est avocat gouvernement qui a argumenté et question toujours tourner le fait que yo campé sanitary les programmes Biden nan statut moun sa yo en masse et c'est ça qui a questionné là.
Benefits that the prior administration thought would accrue to their actions did not in fact occur and were not going to occur in the future.
Okay, any further questions? Okay, you have 4 minutes for rebuttal. Thank you.
Thank you, Your Honors.
Yes, so you're going to have an extra 15 minutes if you need them. So.
Fait yo pour un petit pause là, ça veut dire que nous allons faire avancer, nous allons venir avec avocat, moun k'ap défend moun Biden yo. Parce que pratiquement moun gouvernement yo censé fini là.
Would counsel for the appellees please introduce himself on the record to begin?
Good afternoon, Your Honors, and may it please the Court, Justin Cox for the Plaintiffs' Appellees.
You might want to adjust the microphone.
Thank you, Your Honor.
And if you could start by answering the question I first asked opposing counsel, whether, just for the record to have clear, your claims are purely statutory construction claims, no constitutional. You're not raising a due process claim.
We are not, there is no due process claim presently before the court. We have a due process claim that summary judgment, we have a motion for partial summary judgment.
Okay, but not before us.
That's right, but it's also not the case that we have a pure statutory interpretation question. We have arbitrary and capricious claims which depend on.
Remarquez, avant de parler, juge l'a précisé que faut une classe sur ça, c'est pas en cause du process qu'on va discuter là. Il n'y a pas parlé le fait que le gouvernement viole le process, mais c'est le fait que justement il pas fait et comme tu as dit ça là. Il fait en masse. Donc, juge la voulait cibler, j'en ai l'argumenter, avant, avocat, ou bien dit, groupe qui défend mon Biden, il va aller.
But APA review. You have APA review, and of course, combined with statutory construction. You would agree to that, correct?
Yes, Your Honor, those are the claims. There are no constitutional claims presently before
Okay.
the court. Yes, Your Honor.
35 minutes start running now.
Okay. So jumping right into it, I'll start with jurisdiction. So to begin, it is, Mr. Ensign is incorrect when he suggests that 1252A2B2, that it turns on the nature of the authority at issue. That is directly contrary to Buorfa and Kukana and Biden v. Texas, for that matter. In Buorfa, they made clear that you have to read, and Kukana for that matter, you have to read the statute precisely because immigration law is replete with both mandatory limits and threshold requirements and also some discretionary authority. So the parole statute makes at most 2 decisions discretionary. It says that the Secretary may, in her discretion, parole an individual, and then it states that that when it says what happens when the Secretary has determined, in her opinion, that the purposes of parole have been served. But other than those 2 discretionary decisions, it has, depending on how you count, something like a dozen limits, statutory limits on the authority. The authority has to be exercised on a case-by-case basis.
I think I'm a little confused. So does your jurisdictional argument rest on the fact that the Secretary didn't make case-by-case determinations, or that she didn't determine when the purposes of parole have been served?
Those are both sufficient reasons, but neither is necessary. And to be clear, it is also not unusual at all for a court to conclude that look to the merits in order to determine that a jurisdictional bar applies or not. The Supreme Court did that in 2001 in Zadvitas, and when it explicitly rejected the precise statutory provision that is being relied upon here on the grounds that what was at issue was the scope of the statutory authority. And that, the court said, is never discretionary. And so, of course, the court can reach that question. And similarly, in Kukana, the court, Buorfa and Kukana were both unanimous decisions that emphasized above all that you have to get granular.
Je pense là, faut quand moun Biden yo la vini à bon bête là. La vini avec des séries d'autres cas passés, côté que justement décision parolée ou pas de parler parce que ça argument gouvernement li toujours a discrétion. Ça veut dire la loi bon moins discrétion et que la justice pas gain pour réviser. Et ça équipe Biden a fait là, il a venu avec plusieurs cas à côté que et pouvoir judiciaire là t'es fait une révision des décisions qui gagnent avec parolé. OK, ça relé ou pas argument mais on va venir avec exemple et c'est ça qu'il a fait là.
And precise when you're talking about the attempts to withdraw the jurisdiction of the courts, because you start with the presumption that agency action is reviewable, and you need clear and convincing evidence in order to conclude otherwise. And so even if there are reasonable differences of opinion regarding how to interpret the statute,
you would agree that the Regents of University of California case would allow, that precedent would allow us to review here in this case?
Regents is indistinguishable from this present case. Contrary to what my opposing counsel stated, Regents did not hold that anything was unreviewable. Regents merely, it took for granted the conclusion of Attorney General Sessions at the time that DACA was unlawful. And it said, that's not the end of the inquiry. We're not going to review that because we don't need to. Because the Secretary in that case did not understand the scope of her discretion, notwithstanding that conclusion. And in that case, the Secretary, there was no revocation of authorized grants of deferred action, and in fact, there was an additional renewal period.
En fait, là, il a parlé de exemple Dakar. On va comprendre parce que pour nous comprendre la justice fonctionner, on va faire un argument ou prendre d'autres exemples qui étaient passés. Il a expliqué qui gens ont discuté dossier Dakar au niveau de la justice et que la justice comprenne bien puisque argument du gouvernement c'est que moi j'ai toute autorité de pouvoir parler de parler c'est comme quoi la justice pas ta droit pour venir entre bouche là-dedans. Et là après il prend plusieurs exemples côté que effectivement parce que Dakar son forme de parole parce que les Dakar les non deferment of action. Vous comprenez? Donc c'est ça à parler là.
that was offered to individuals. If their deferred action was going to expire within 6 months, they could renew for another 2 years. And the court said, nonetheless, you have to consider alternatives that are within the gambit, which, and here they said, there are 2 pillars of DACA. One was the forbearance policy. One was the was providing of benefits, and Secretary didn't consider simply doing the one and not the other, and she should have, and so it was arbitrary and capricious. And additionally, she failed to consider the reliance interest. And there, the reliance interests cannot be distinguished. Individuals, members of the class moved to another country, and because they were told they could do so if they went through this process, and once they got here, they could apply for other forms of relief. They, of course, were told, just as deferred action recipients were told, that this can be ended at any time. And the Supreme Court rejected there, too, the argument that that was somehow dispositive. And they said, absolutely not. You have to take into account the legitimate reliance interests, even though DACA had been in place for 5 years when Secretary Duke came in and sought to end it. And because the Secretary had failed to consider those 2 important issues, they said it was arbitrary and capricious, even assuming DACA was unlawful. And so it's indistinguishable. And it's also worth noting that the government argued in Regents that there was no law to apply, that 5 U.S.C. 701A2 precluded review because there was no way to tell whether or not Secretary Duke's decision was an abuse of discretion, because deferred action was not statutory nor regulatory at the time. And so how do you measure it? And the court had no trouble rejecting that argument and then applying traditional arbitrary and capricious review. And I can continue with
Là, la parle de Dakar, côté que, effectivement, tribunal là, c'est un cas côté que gouvernement ça te gen doit dire pas de review, mais la justice t'est prononcée sur cause Dakar, OK?
with jurisdiction, if that would be helpful. A couple of other.
Let me move you
Please.
more to the merits. So one of the arguments the government made here today was that given what we're dealing with here, humanitarian parole, a categorical reason might support termination for a group of people. Say a civil war in a country has ended. And that argument supports their merits arguments here. That seems to make some sense to me. How do you respond to that?
I'd say at least 2 responses, Your Honor. First, even assuming that it was permissible sometimes to rely on categorical determinations to terminate parole, that's not what the Secretary did here. If we look at what the Secretary actually did, so I'm looking at page 46 of the addendum, and of course it's a basic principle of administrative law that if the Secretary's decision is to be upheld, it has to be based on the 4 corners of this explanation. And on 46 in section 3rd, Secretary Noem acknowledges that when each of the parole processes were created, DHS said that they would serve both of the 2 statutory purposes of the parole statute. They would provide significant public benefits and serve urgent humanitarian reasons, or address the urgent humanitarian reasons in the 4 countries. And in section 3 of each of the FRNs that create the parole processes, it says justification for the processes. Subsection A, significant public benefit. It has 6. It lists 6 significant public benefits that it would serve. Secretary Noem ticks through those right here in addendum 46. And then in each of the FRNs creating the processes, there's a subsection B. It says urgent humanitarian reasons, and it explains the country-specific urgent humanitarian reasons for the parole processes. Those reasons are wholly absent from the explanation that Secretary Noem gave.
But the statute provides.
En fait, avocat ça va un bon argument là. Il a expliqué que chaque pays en fait dans 4 pays yo te désigné pour parler à yo, par exemple Haïti yo te parlé d'insécurité ou ensemble de bagages, mais par contre, il expliquait que les nous bral fini par parler, elle pas tenir en rien de caractère ça. Vous comprenez? Alors que en fait, pas oublier que argument que avocat gouvernement bail, yo dit qu'on y a pas un problème sous frontière là encore, c'est un problème sous frontière, mais il était qu'à une raison si c'est, nous connaissons les gens qui traversent les frontières, les gens qui ont flush, même, m'a parlé de gens qui gagnent C11. Ça nous les DT. DT, même, ils flush net, ok? Il était qu'à une raison si c'était DT. Pas oublier que même moun baden yo pas DT, yo c'est HHP en parlant de haïtien. OK? So, argument ta pral bala là c'est pour causer frontière, li pas gen sens. OK? Donc c'est ça on devait souligner pour.
For urgent humanitarian reasons or significant public benefit. And doesn't she address the significant public benefit to the United States?
Yes, Your Honor, but the processes were justified on both grounds independently,
But
and she only addresses one.
when you say, I didn't see anything in the language of the Secretary's description that supports the suggestion that each of those purposes or benefits was by itself sufficient. She seems to have said, to the contrary, that it was necessary. So as I understood the government's argument, they're saying a necessary purpose of this program was to relieve congestion at the border. Times have changed, and the new secretary has determined that that purpose has served it by other means, and therefore the purposes of such parole shall, in the opinion of the secretary, have been served and terminated on that basis because that purpose was no longer satisfied.
The Secretary...
And if that was a necessary condition of the parole, then there's no need to look at whether the other necessary but not sufficient conditions were also satisfied.
That is not my understanding of what the government has argued to date, Your Honor, and that's also not what Secretary Noem said.
Hey, can you point to the language in what Secretary Noem says that would suggest that the purpose of relieving congestion at the border was not enough?
Il y a parlé de congestion qui te gain sous frontière là, OK? Pas oublier que argument gouvernement il dit que pas gain congestion sous frontière là, mais pas gain nécessité pour Biden. Oui, il a raison si il campé ça dans l'application. On a parlé de I-134 que je ne dis à mon pas gain cause application. Vous comprenez? Mais c'est pas cause de bloquer s'il bloque application pour dire bon nous pas un problème sous frontière, nous pas dans cause faire application mon Biden. Là, il a raison, OK? Mais c'est pas ça le fait. C'est pas bloquer l'application. Il bloquer des séries de monde qui étaient déjà sur le territoire là.
Necessary condition.
Well, so to be clear, there were 6 bases for the significant public benefits in the original creation of the processes. And Secretary Noem addresses those and gives her view that considering those 6 items, and she ticks through them in, addendum 46 through 50 or through 51. She goes through them one by one. Her item 4 actually includes 3, and that's why she addresses all 6. But there was a separate independent basis for each of the grants of parole and the processes themselves, as established, and this has not been disputed. She acknowledges it herself in addendum 46, that DHS stated that they would provide both of these. They would both serve urgent humanitarian reasons and provide significant public benefits.
Yes, but after listing them, she then listed the reasons for the termination, and then she said, I quote, "These reasons independently and cumulatively support termination."
Yes, Your Honor, but the sentence before that is her solitary explanation of the why she no longer believes the urgent humanitarian prong of the statute justifies the programs. And she says, and I quote, "Regarding previous arguments or determinations that these programs were consistent with the requirement of urgent humanitarian reasons for granting parole, DHS believes that consideration of any urgent humanitarian reasons for granting parole is best addressed on a case-by-case basis."
Yes, but you're just reading her litany of reasons.
No, Your Honor. What I'm saying is this says nothing. Like she...
Well, she does. I'm looking at the beginning, the rationale for initial implementation, where she identifies the reasons.
Right, and
She
those...
lists a number. One of them is the programs that she finds does not serve a significant public benefit and is not necessary to reduce levels of illegal immigration. She then lists the humanitarian reasons, but she then says those reasons independently support termination. How do you get around that?
Well, Your Honor, she doesn't list any of the humanitarian reasons.
Well,
The sentence
I just read you,
is-
she listed the public benefit of reducing levels of illegal immigration.
Yes, Your Honor. She addressed one of the two
And she
prongs
says that
Mwen nou d'akor la gen yon ti dezakor ant
as meeting the statutory standard. There's no question that she has an obligation under Encina Motor Cars and Fox Televisions to acknowledge the facts and circumstances underlying the prior decision when rescinding a policy. And so she needed to address the urgent humanitarian reasons that were an independent justification.
why
of
do
the-
you need to, if you have two reasons for doing something, reason A and reason B, and both are necessary, you wouldn't do it without both of them. Once you determine reason A is no longer applicable, why do you need to look at reason B?
I think the disagreement, Your Honor, is that there's no evidence to suggest that both were necessary.
And what do you understand she meant by the word independent when describing the first reason A?
Well, I see the statement where she's saying these reasons, but she's incorporating a prior discussion, and the sentence right before is an entirely circular sentence that is crafted to say nothing at all. It doesn't say that she disagrees with the prior determinations regarding urgent humanitarian reasons. She doesn't say what they were. She merely says that DHS believes that they should be met, or can be addressed through the case-by-case
Now
basis.
you're talking about reason B. But my question to you, and I'm trying to think this through, this is tricky stuff, but it seems to me if she's saying that reasons A and B are necessary, and reason A, she clearly says, is no longer being served, what's the counter-argument to that? Help me understand that.
Well, I think the counter-argument, Your Honor, is that Secretary Noem doesn't get to decide what was necessary with regards to the prior decision, right? She doesn't get to recast that decision and say, Secretary Mayorkas said both of these were required.
Okay, so what's your evidence, and let's go outside of what the Secretary has said here. What evidence is there in the record?
Fòm di nou ke juj sa li vreman coincé avocat moun kap defend Biden. Ouais, li pose plus question de l'autre juge mboko. Ouais, li même c'est de l'autre juge mboko même parler là.
That you can point us to that would show that this parole program would still have been done but for the desire to reduce congestion at the border.
Well, Your Honor, I don't think that's in our view, the standard is you evaluate what the reasons that the agency gave. So we don't have to prove the negative. We don't have to prove that somehow the Secretary Noem would have reached a different decision. The only question before us is, what did she say about the independent basis that her agency previously gave for establishing these processes? And she that DHS opinion, a couple pages, gave its reasons. And then when the second case came up on an indistinguishable posture, they said, hey, we told you how this all shakes out. They didn't do that here. And so this court would be speculating if it sought to assign a particular meaning to it. And the last thing I'll add is that the Supreme Court, the order in this case, itself contemplated that this appeal would proceed in the ordinary course.
So I hear you saying two things.
The singular that's used at the end of the relevant paragraph here suggests that the case-by-case should carry through the whole.
I think that was one reason. Another reason is, in order to determine that the purposes of someone's parole have been served, you have to at least know what the purposes of the parole was. And so again, even if categorically the Secretary could theoretically address the urgent humanitarian bases for the processes generally and the individual grants of parole, that's not what she did here. And so it's not, this panel doesn't have to reach the question of does the statute require a case-by-case for termination, because that's not even what she purported to she didn't even do it categorically. If I may accept a couple of responses.
Just continue on, there may be some more questions.
So I wanted to address the 1996 amendments. We have substantial record evidence that INS understood well before 96 that the parole authority had to be exercised case by case, and the 1990
Regarde, jugement arrêté à peu près 15 minutes comme ça pour le finir. 10 minutes comme ça.
76 amendments did not simply insert the words case by case. It actually, the statute, in IRA had 4 different sections that had impacts on parole, and none of them, it's simply not the case that it would somehow be superfluous. And there's no evidence that the executive thought that it could act categorically prior to 1996 either. And the Lake and Riley amendments also don't carry the weight that that opposing counsel has suggested. It had, in fact, Lake and Riley has nothing to do with reviewability at all. It's about standing. And it was enacted because a number of states have sued unsuccessfully in recent years to challenge parole policies. And so Section 3 of Lake and Riley added language, much like subsection C now in the Parole Authority, to the parole statute and 4 other statutes, each of them corresponding to losses at various courts by states. And so, but all it's standing, it's not reviewability at all. And if anything, it indicates that Congress intended and knew that these decisions were reviewable because they didn't enact a cause of action. They didn't adjust any sort of jurisdictional bar. Instead, they said that states shall have standing in these circumstances. And so that supports us rather than undermines any suggestion that, that these decisions are reviewable. And then I also wanted to answer quickly the question of how these programs ended in the past. Typically, parolees have been able to adjust into permanent status, either through existing authorities or quite commonly, Congress has enacted legislation giving them a path. This is discussed in the Cato amicus brief, and also in the record we have a list of the 125 or so prior categorical parole processes, along with citations to the statutes where Congress gave a path to lawful permanent residence for the parolees. So that's typically how it's done.
This particular statute did not provide that path.
Congress has not enacted
And when this statute was passed during the Biden administration, that could have been done. Could have been said, if after X number, or X period, this path, these individuals who are paroled can take this path. This statute does not allow it, as it's written right now.
Well, previously, the parole statute didn't provide for it either.
Là, il a parlé de moun qui a traversé de parler pour aller une résidence. Vous comprenez, c'est ça discuter là.
It was either existing authorities, for example, about half of our class members, as of March 9th, had pending applications for other forms of immigration relief.
Yeah.
And so it's that kind
Monsieur explique parce que moitié moun sa yo gen pending application pour l'autre statut.
of relief, or Congress enacts a new statute, not related to parole, but simply said, not related to the parole authority, but that says individuals who are paroled in through these particular processes can adjust status.
Okay, but here, for that particular statute, that is lacking right now. Congress could tomorrow, or, in the future, do it.
Yes, Your Honor.
And let me also, since you mentioned, you said that about half of your parolee clients have some alternative, perhaps relief. Could you clarify that a little bit or explain a little bit more?
Sure. So as they were told when they come in, they could apply for asylum or adjustment of status or temporary protected status.
Let's assume the parole is terminated. Those who have applied for asylum or some other form of relief, they could, if those processes are still ongoing, they could remain in the country, or if they have an appeal pending administratively for asylum or whatever.
Well, actually, in January, Your Honor, as soon as the new administration came in, they suspended the adjudication of any benefit application that was filed by any of the class members. That was recently stayed by Judge Talwani. That was a notice of appeal that was filed yesterday on the 60th day after the decision. So the administration actually, their intent was to preclude the class members from getting relief. And many of the forms of relief that the applications that they have pending cannot be raised in expedited removal. In fact, none of them can. Even if you have an asylum claim, if you are put into expedited removal, you have to convince.
So in other practical terms, we're back to the 430,000, the number, because out of that number, there's not a subgroup that has right now any practical remedial, alternative.
So certainly, members of the class are pursuing those who have stayed. Some have left voluntarily. Some don't even know that they have had their parole terminated. But they're certainly pursuing those forms of relief. But the practical avenues available to them right now are quite narrow. And as we've pointed out, Secretary Noem doesn't even acknowledge the contemporaneous action of her agency to suspend the adjudication of their benefits applications. The whole point here is to just push them out, but you have to at least go through the appropriate process.
Let me, just one other question, I think this would be my last, and brother, colleagues will.
Oui, t'es à peu près 9 minutes. Il dit plus, 9 minutes.
May have some other questions. Let's assume we were to determine or to hold that determination of parole has to be on a case-by-case basis. How are you exactly proposing that this has to be? Because there would have to be, of course, a letter served personally. I believe you already said that, but what would have to happen after that? Are they entitled individually to a hearing, to other review? And again, all of this also in light of the APA, the Administrative Procedure Act. So what more else does the government have to do if it's individual and they're all served with their letters? And their letters can be understood by a 3-year-old.
I think we're speculating about a potential action of the Secretary. We don't think that that's particularly relevant to what she did here. And we understand that that question might arise later, but she fell so far short of what's required by the APA here that the court doesn't even have to reach those questions. So for example, the reliance interest and alternatives, the only reason she gave for overriding reliance interest and rejecting the 2 alternatives that she considered was this expedited removal, her understanding of expedited removal. But defendants have now conceded, in fact argued, that was in fact a contrived reason, because she also thinks that she can put parolees through expedited removal forever under the other prong of the expedited removal statute. And so their argument is that it was the one reason she gave was doing no work. They've conceded it, and essentially they're saying no prejudice. But to get there, they have to argue that the only reason that Secretary Noem gave was contrived.
But let's assume we were to rule in your favor on the APA grounds. There is no stay, so the administration continues, as Judge Callada has been mentioning, could remove these individuals or terminate the paroles while that case is pending. The case would be pending before the Supreme Court. But couldn't the administration at the same time saying, even if we find that this violates the APA, they could go ahead and restart the whole process again and do it in a way that complies with what was not done here. Am I correct?
So they would not be prohibited from trying again. That's absolutely right. Just as in Regents and with DACA, they could try again. But as DACA is still here, we're many years later because the administration chose not to try again last time, and they haven't tried again yet here. And so I understand the point, but the Supreme Court in Regents actually considered this too. They said, we understand requiring the agency to go through these procedural steps again can seem a little sort of self-defeating or unnecessarily burdensome because we all know they're going to get to the same place. But they rejected that argument, the precise argument that Your Honor is positing in the Regents case. And so we understand what you're saying in terms of the mootness. I think the most recent grants of parole to a class member was probably in January.
Okay, but let's assume a victory for your client in this case is perhaps a victory in round 1 out of 10 rounds. I don't know how many
Understood,
rounds.
Your Honor. Yes.
There would still be other rounds of action and litigation, I would assume. It just takes you back. It takes you back to the status quo.
Yes, Your Honor. That's right. And we think that that's quite valuable. At a minimum, it would let our clients and the class members have the dignity of leaving on their own terms, as opposed to being subjected to the kinds of removal and detention processes that are happening right now.
Okay. I have no further questions. If my colleagues have any, please go ahead.
No, thank you.
Okay.
Thank you, Your Honor.
Thank you very much.
Semblez-vous finir avec question yo?
Thank you, counsel.
Counsel, you have 4 minutes of rebuttal.
Bon,
Please reintroduce yourself on the record to begin, sir.
OK.
Drew Ensign,
So, guys, yo, ça c'est fini là. Ça veut dire que c'est tande aujourd'hui, hein. But, il veut dire, généralement, les autant de ça veut dire que c'est même jour pour yo rendre décision. Donc, il y a bien pour y aller prononcer yo par la suite. Voilà. Et il y a bien pour y aller prononcer yo par la suite. Et, entre parenthèses, faut me dire nous que gon l'autre cas qu'a discuté qui concerne moun Biden yo. Et nous promettons pour nous porter pour, c'est le cas, effectivement, parce que c'est grave, c'est le cas des séries de monde. En fait, je parle toujours moun Biden, je parle surtout humanitarian parole. Euh, nous connaissons que l'ensemble d'applications moun ça a été fait, que ce soit application TPS, que ce soit application asile, que ce soit d'autres applications résidence, il te suppose. Salvani va passer l'ordre et il te dit retirer pose là. Mais ça qui passe, c'est que l'administration propose qu'elle obéit, but, par exemple, il dit, statistique qui sorti pour moi, je monte c'est 9000 cas seulement que vous process. Nèg yo style a fait là. OK? Donc, yo pral traiter dossier ça à la justice pour que nèg yo, parce qu'il y a joué un jeu de marronnage là, puisque yo fait processus là vraiment lent. Pour moun, imaginez un monde qui font 4 travail sur asile. Il suppose venir dans 30 jours, et ça lié. Comment comprendre 4 mois, 5 mois, il va make sense. Donc, dossier ça a bien pour le discuter et tout. Nous pour maintenant faire effort pour nous essayer de capoter pour vous. Parce que ça me pense que le dossier c'est beaucoup plus important. Et ça a bien fait là, son dossier a bien ressuscité. Ça qui arrive le bon, parler de ressusciter, dans le sens que moun Biden yo, dans le sens c'est, là dit moun Biden yo, de qui moun? Mais si tu vas parler de série de moun qui te gen 4 qui t'a pas l'expirer pour 2026, yo pas en pile là la vérité. Vous comprenez? Parce que puis bon moun Biden là 4 yo expiré déjà. Est-ce que vous comprenez? So y a bien sauvé que ça. Pour un pile moun il était bon, s'il ka sauvé. Vous comprenez? C'est ça qu'a fait dans pile là. OK, but son façon pour dire que bataille ça est toujours vivant, OK? Même parce que ça qui est important, hein, c'est pour forcer le gouvernement à décider rapidement sur des cas de travail, des cas de résidence, côté que nèg yo a fait ça on vetting, vous comprenez? Yo fait beaucoup plus lent, vous comprenez? Et donc n'a bien pour nous suivre débat ça pour tout. OK guys. Nous promettons que n'a pas live sur YouTube Palmis Mapou, je crois à partir de 9h40 et là ça va nous monter jeudi, donc nous bon rendez-vous pour nous continuer à parler guys. Donc c'était un grand plaisir sous base ça.